Hello, YouTube. I'm Vince White. I'm an employment attorney on this channel. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. This is day 3. Well, not day 3. This is the third video in like an hour after I installed the sound deadening materials that I'm hoping will get rid of the whistling sound or the grinding, whatever it is, sound. So please let me know down below how I've done with that. We have a question from a YouTube user. Ooh my. I believe it's multiple O's on the ooh, so it's ooh my. I think. Did I get it correct? Is that how that should be read? And ooh my says, Vince, can you cover a talk about evidence and or discovery or an evidence hearing? Like what evidence does the opposition get to have? And if they have all the same evidence, doesn't that just give them an advantage to understand your trial strategy? Yeah, so super valuable question. If your case is going to be taking place in federal court, most state courts, or really any arbitration that I'd be aware of, any evidence you intend to use at trial will be traded with the other side, will be exchanged. So the discovery process generally is going to have two parts. I guess you could say three. It's going to have interrogatories where each side gets to ask the other side questions and the other side has to answer honestly. It's also going to have document discovery, long list of documents that the other side is asking you for and that you're asking the other side for. And then they'll get the document discovery list and they'll have to do a bunch of digging and get everything together that's responsive and send it over. And often at either the interrogatory or the document review stage, you'll have motions to compel, depending on where you're litigating, because your attorney might feel, or the other side might feel, that one side or the other has not been sufficiently responsive or honest in their responses to discovery. There's motion practice, there's fights, there's scuffles, but generally speaking, the scope of discovery in this field is broad. Not endlessly broad, but generally broad, right? A lot of times you can ask for, like, what's the hire and fire rate for people for this protected class versus, let's say, white people, right? Like, that's a common type of thing. And the other side will be like, well, that doesn't matter here because you're saying that this person did a bad thing. We're like, well, actually, we're saying this person's part of a systemic problem in your organization, and we'd like to know just how far the problem goes, right? And there's going to be scuffles about what we get and what we don't get. The important thing to remember is, because you're worried about them knowing your trial strategy, anything that's going into your trial strategy, they will get. Oh, wait, I got to get to the third part. So once you have all the interrogatories and document discovery done, depositions are going to take place in most venues, right? And depositions are going to be witnesses being questioned under oath before trial. They don't have to be questioned in the same way that they would be questioned at trial, and they don't have to be asked the same things, and the things that they are asked don't all have to be asked at trial. So there's a lot of leeway, but there's going to be questioning of witnesses before trial, and you may have heard the famous phrase, never ask a witness a question you don't know the answer to at trial. That phrase exists because depositions exist, because you get to ask them questions under oath, and they answer under oath, and if their answer is different under oath one day from what they say under oath the next day, or at trial, that's going to cause some problems for their credibility, and maybe for them in terms of liability, criminal liability, potentially perjury, right? Depending on what they're saying and why. Now, so you've got those three phases of discovery, and it probably sounds pretty clear to you at this point that most of the questions are going to be asked. Not all. There's going to be some questions that crop up later that maybe didn't get posed, and attorneys are going to have to make hard choices about if they pose them at trial, if they can back it up with documents to hold them to give an answer. There's a lot of thought that goes into this. But yeah, the other side is going to have the evidence. So one of the ways that you try to not give away your trial strategy is you try to go very broad as you can, right? If you have 3 hours of deposition questions that matter, you might go a full 8 hours on a deposition to try to make sure that the other side's not entirely positive about how you intend to use this witness. If you think you need 10 documents, you might ask for 10,000. Right? I mean, or conversely, employers will often just data dump huge amounts. This is one of the issues that solo practitioners have, right? Like, we've had cases where the other side is like, okay, so we've produced 10 terabytes of responsive documentation. Good luck going through it. And then you need to throw additional resources to that. More people from your firm, deposition coding, document coding services, contract attorney. Like, you need to scale up to properly digest that much information, and maybe have a fight about, how it was provided and things of that nature, and it needs to be word searchable. There's a lot of things that have to go on there. So, I mean, on both sides are doing this, right? This is a common tussle. But generally speaking, when your question is, what evidence does the opposition get to have? All of it. All of it that you're going to use. Because if you go to trial and you start trying to use evidence that has not been exchanged prior to trial, you've got problems. I'm not saying it won't necessarily get in, but there's a lot of risk it might not. And it's not how you want to be conducting a trial, right? There's rare situations where you might do some theatrics and try to bring something in, it doesn't get in, and the jury gets annoyed. Like, there's stuff that you can do, but even then, people are pretty on top of that, and they're going to try to make sure that doesn't happen in front of the jury, and your attorney can get in trouble for that sort of thing. Which is why I wouldn't personally do that. It might be unethical. No, I wouldn't. But the drama of employment law. Employment attorneys are the worst adjusted drama kids, right? The evil drama kid who sat in the corner and plotted dropping sandbags at the school play on the lead, so he or she could take the lead, right? That's who became the employment attorney later on in life. I just say things. Don't listen to me. But yeah, all the evidence is going to get exchanged. 99.9% of all evidence will be exchanged. Anyways, I hope this is responsive. I hope this answers your question. Do you have more questions? If you have some specific drill down questions, I would love to hear them. I'd follow up on that and try to give you answers. Just comment down below if this video is helpful. If this video is helpful, like, subscribe, and comment down below. Share our channel so it can grow. Somebody shared our channel recently, and it got 20,000 views in the share. I don't know who that was, but thank you. That was a lovely surprise. It was quite the spike. It's quite the spike in the graph. I hope all is well, everybody. Take care.